Добрый вечер. Давайте постепенно начнем.
Good evening. Let's get started. Maybe some people will join us a bit later. So for now, I'm going to make a couple of opening remarks. My name is Alexei Kozluka. I'm one of the co-founders of Human Constant. We are a human rights organization, and of course, we cannot miss the questions of privacy, personal data protection, and digital freedom. So this is a rather important issue all over the world: Cambridge Analytics, Facebook, privacy leaks, GDPR, that lawyers are anxious about all over the world, not just in the European Union. I think we'll try to discuss as many questions as possible related to Belarus, like to our local context, so what's going to happen in our country, how privacy and personal data are going to be protected in the near future, what's the role of business and the state in that process. Besides that, we will talk about some questions related to the region and probably several of the global ones, so that our discussion is not entirely about law, because the question about personal data protection, it's not the question of procedures and technical protection, but this is the question of why it was all initially started. That's the question of protecting individual, their privacy, and the borderline between the public and the private. We'll try to take a look at these questions all together. So that we can do that, we're going to invite our wonderful speakers, and they will help us with that. Sergey Varankevich, the Director of Data Privacy Office. Sergey deals with business consulting and also with public associations in terms of personal data protection. And he tries to enlighten people, however possible, about what personal data is and how to protect that. Sergey Boziano, Director of Data Protection Services with law. He's from Moldova, and he used to work a lot in the state system. He was one of the persons who participated in establishing the system of regulating these things in Moldova. Of course, he will go into detail a bit later, but on the whole, we see quite an obvious wish to comply with the European standards of data protection, and we see consecutive steps to do so. So I think this is one of the countries that will soon announce full readiness to GDPR. And I think Sergey is going to tell us in detail how they do that and why. Now, so that we have a better understanding, I will be calling Belarusian Sergey, and the Moldavian Sergey will be Sergio. Alexandra Kulikova, that was already introduced today. She represents ICANN. Now, why ICANN and what ICANN has to do with personal data protection? Well, this is one of the first cases of international application of the regulations on personal data protection, so that is in place in the European Union. This is a good example of how we were planning to do one thing, but eventually did quite the other thing. So now we have a certain replacement. Instead of philosophy and culturology, in terms of privacy, we're going to be speaking more about the questions of protecting personal data, especially given that Alexandra can provide us a broader view on that from two perspectives: from the perspectives of private sector and public agencies. He used to be one of the first people in the state system who raised the question about the necessity of introducing a law about personal data protection. We don't really have presentations. I would like this to be interactive discussion. So we want to pay as much attention as possible to live discussion. And there are questions that I would like to ask all of you. This question will be on screen. We will be voting in real time, and we will see the outcomes. The discussion that was held in May last year ended up in some of the participants of a discussion saying, yes, of course, we discuss that. Yes, of course, this is the topic of interest to the lawyers, but we think nobody else is interested. So, yes, let's post this on the screen. Let's try to see whether or not there is a consensus among the participants of today's discussion in terms of how anxious we are about our personal data. So let's start. Let's start with Sergei. We're all interested in what is happening with personal data in Belarus. What is the status quo of the legislation, whether or not it is just about the legislation or maybe something else, and what is to be done in such situation. Thanks, Alexei. I cannot really see the back rows from here, so with your permission, I will stand up so that you can see me and I can see you. Indeed, Belarus still does not have legislation on personal data, but as we have seen from our honorable colleagues from the public agencies, we're planning to establish a law. The people, the Belarusians, largely think that personal data is the legal question, so this is not, there is no lies in that when we say it. But when we take a look at the specific situations, such as getting SMS or emails that is like on the mailing lists, and using personal data so that some fraudulent activities are carried out with the use of the credentials. Everybody understands the risks, but we still do not relate the notion of personal data to these situations when we think about that. But now we're moving towards protecting people from such unsanctioned use of personal data. When somebody is using my personal data, say, to harm somebody. In this situation, our public opinion and public consciousness is far away from the environment where Belarus is, and which is interesting because we have the neighboring countries and the European Union in the West. All of them have personal data law. GDPR is a widely known law on personal data protection. It is much stricter than anything that has ever existed before. And our legislators, largely and reasonably, want to protect the business economically that has to work with the personal data, including European. And of course, it was economic aspects that provoked the trend to establish the new law on personal data. Of course, the social initiative was less so. And so right now I'm heading a company that deals with consulting in the sphere of preparing for the GDPR. We are consulting Belarusian, Ukrainian, and Baltic businesses in terms of how they can follow the European regulations. And I myself witnessed such a phenomenon when most of the companies deal with that, treat it like one more formality. So they think that their core business is not going to be affected by the situation. This is just, as they think, a burden, an additional expense, which is the fault of those European bureaucrats, quote unquote, which basically is the reaction from this startups, so then they do not really understand why they are forced to minimize the data, delete the data, and so on. And the attitude is rather skeptical. Last week, there was GDPR Day Moscow, and in the High School of Economy, the whole assembly hall was full of people, and I asked these people that were, on the one hand, the consultants and internal DPOs, like data protection officers, people who protect personal data of people in organizations. I asked how many of you came to GDPR Day avoiding the high fines. About 40% of the audience raised their hands. Now I asked how many of you came because you received a letter from your European customer. And actually, there is an obligation for the customers to ask the processors who are processing the data. Another 40% raised their hands. And final question was, how many of you came because you respect privacy of your customers and you think that this is a competitive advantage? How many people raised their hands? Essentially, it should have been 20, but there was only one person who did. Other people eventually just happened to be in the room by chance. This one person who raised their hand in Moscow is basically comparable to GDPR Day in Minsk. We had two events of this kind in May and June. Well, we were really happy to see that Belarusian audience was much more enthusiastic about respecting their customers. There were 5 or 6 people, but the majority of people still want to avoid paying fines and preserve their niche in the European market. And this is wrong, because personal data and your care for the people may be a competitive advantage. It may be a strength of your business, and it may potentially not only be the cause of headache for your employees who have to comply with another instruction on personal data protection, but also an added value, a greater revenue because of increased loyalty of customers to your company. And this may help you attract more customers, basically. Currently, we have a trend that Europe-oriented business is export-oriented, protects their personal data and, of course, our personal data as well, because it is not economically reasonable to segment the personal data into different systems and protect European and not protect ours. Luckily enough, they protect all personal data irrespective of where the individuals or entities possessing these data come from. But I think the motivation is the second most important one. Basically, they still just want to avoid fines and they want to preserve the European market. Right now, we as Belarusians still do not fully realize the importance of our personal data, of our birth dates, our track record, our job history. We don't yet realize how important it is for us to behave on the internet, how important it is which websites we open. At the same time, but this basically entails a lot of risk, and luckily for us, the European Union already started thinking about that. They have joint regulations of protecting personal data. But the huge segment of Belarusian business that is fully oriented on the national segment, domestic segment, will only start thinking about protection of personal data after the introduction of a national level law. I think Humans Constant and other public associations need to educate our society so that we have the need not only from the businesses and public agencies, but also from the population, from the society, so that there is demand for protecting data and protecting us from the possible consequences that such use of this data might cause. Thank you, Sergey. We see some first results already. Of course, the personal data section gathered people who really care for that. but I think that we may have people joining us who are not here physically. So basically Belarus is at the beginning of the path. So Sergio may share the experience of well, actually they have made already 2 or 3 steps forward. And the question, of course, will be, is this just a formality to sign the association agreement? Did it transcend the level of formality, and how Moldova perceives that as an additional burden for the business, or as a real tool for protecting the rights of the citizens? Hello, I'm happy to see so many people who are interested in protecting personal data. I will share my experience about what things are like in Moldova. It all started in 2007 when Convention 108 entered into force, which we signed. In 2007, we introduced the first law on personal data protection, which later on was changed to a different one that was compliant with the European directive. So currently we still have this law that says essentially the same as the European directive, which unfortunately on May the 25th was nullified when GDPR entered into force. Initially, the development of this law consisted in our country fulfilling the requirements for signing the convention. After signing the convention, we signed the agreement with the European Union, where we clearly indicated that we took on the commitment within a short period of time to bring all the operations of personal data in compliance with European principles. Now we're at stage 3. We have developed 3 or even 4 laws. One is related to GDPR, another is related to the national body on protecting personal data. The third one is related to video surveillance, everything that has to do with cameras, and the fourth one is the cybercrime, something that also has to do with personal data. So from 2007 to 2018, significant changes have taken place in terms of business. When I heard about the personal data for the first time, I heard that we need that. There are additional resources needed for that, but we don't have the resources. More and more experts came explaining to us what personal data was, and it became finally clear that if we wanted to work with the European Union, we had to comply with the requirements they had. So there was a lot of investment from the European Union, and they understood that it was really important for outsourcing. Currently, we have favorable climate for the investment of the European capital to come to the Republic of Moldova. And in this case, the numbers quite clearly show that more and more companies come, and they are not afraid to transfer all of their databases. And even the medical records systems were transferred to Moldova. However, all the data is processed according to the EU law. Why we need that? On the one hand, it is to observe the rules to protect human rights. On the other hand, when a customer comes to a certain company, it is important for them that the company does not sell the data, does not use the data for some other purposes. And this is important for telecom, for insurance, for finance, for IT. Currently, you as the companies represent the controllers of the use of personal data, but we are also the subjects of the personal data. So you basically provide your own personal data that are processed by some other companies. Now, you need to clearly understand what the prospects are and why you need that. And in relation to that, I would like to ask a question. What do you know from your parents about your parents, and what will your children know about you and about the others? Is there any difference between what we know about our parents and between the information that our children will know about us? Do we have a right to privacy or to the confidentiality of private life? We only know the good things about our parents, but we would basically like to know what actions they performed, what offenses they committed, or Facebook. Did they have any Facebook? Do they have any photos and so on? Are there any people in the room that have nothing to hide?
If so,
If there are any.
If so, I have seen one of you raising your hand. So, I guess. If so, I guess we're not going to waste our time on the comment here, but I believe that. So anyway, the security of personal data is a question of today's reality. These are not data in your passport, but any data that you accumulate whenever you fill out some contract or some form, whenever you access the internet, and so on and so forth. So our data are always recorded somewhere, either in the written or in the digital form. So one day we can wake up with our apartment being sold by someone else or some contract being concluded by someone you don't know. I've spent 6 years working in the National Center for Personal Data Protection, and for the first time when we started to consider such cases, we believed that half of them were actually ungrounded, but at the same time, only the person who finds himself in some unpleasant situation has a clear understanding of what personal data security is about. So whenever you have some alimony not paid, or whenever you are banned from crossing the border, it is only then that you understand how important your personal data are, how critical they are. In the Republic of Moldova, the first steps have been made in order to ensure compliance with the European standards, and probably not the standards of the European Union, but the generally acknowledged European principles, because they stand also for the Russian Federation, they stand for Ukraine, and for any other country, any other state that is involved in data processing and that has signed Convention 108. So, further on, should you have any questions, I will be most glad to respond to them very clearly and give you an insight into the developments in Moldova, as well as the problems that we faced when we were drafting the legislation and we were bridging the relations with the law enforcement agencies who were telling us that they are not involved into and should not be involved into the data processing, or whenever we addressed some operators who were saying that the clients' databases were not about personal data but only about some personal business processes, so thus can be labeled as classified information. So we should clearly stipulate everything and set out everything that we are going to do with information. So all of that should be set out in the legislation, and we should clearly understand how we are going to observe the European principles for personal data protection. Thank you. Thank you very much. That's a truly interesting experience, and I wonder whether we're going to follow this path or are going to search for our own one, or to borrow the best practices of some other countries. Anyway, we are considering GDPR as some flag, so to say, or something that has come from the European Union and that will in a mandatory way make our rights more protected. But the question how GDPR affects the already existing institutions and the things that initially were not related to privacy but to vice versa data, openness and global functioning of such things as a global register of domains. So this is an interesting case that appeared during the first day of GDPR. Thank you very much. This problem was acknowledged earlier, and we're not prepared enough to resolve it somehow. I'd like to remind you of the essence of the case. So, for those of you who are not knowledgeable, going back to the first session, I mentioned that GDPR turned out, or if not turned out, it seemed to be a stronger legislation than it actually is. So indeed, it affected in a surprising way the fields of activities where the effect was not awaited. So speaking about ICANN, this is a good example of the way the extraterritorial principles of GDPR execution act, because we are discussing this in Belarus, and the same question was discussed in Ukraine and Russian Federation. So instinctively, 1 year ago, we believed that this did not relate to us, but it does actually. And some time ago, it turned out that it is relevant not only for businesses, but also to some institutionalized structures. So what is the essence of the ICANN case? The essence of it is in the fact that the domains registration system is based on the protocol that was drafted in the 80s, like more than 20 years ago. And it sounds WHOIS. Its name sounds as WHOIS. So by and large, this is a database of registration data for the domains, and the most relevant for us are the ones belonging to the upper level. So these are the databases that have a lot of personal data, including the names, addresses, indexes, email addresses, cell phone numbers, administrative contacts and technical contacts, as well as potentially some registration data of legal and entities and individuals, but the GDPR does not differentiate between those actually. And this resulted in the fact that the WHOIS database that was used for quickly getting in contact with the owner of the domain and inform him on some breaches and the breaches of his territorial rights and some technical issues. But today, this database cannot exist as it used to previously, because it used to be accessible to every one of us. Over time, this database also turned into a huge chunk of information for all of those who need our personal data for spamming and performing some other criminal activities online. So the limitation of the use of this database is quite relevant on the one hand. However, the previous session was dedicated to the issues of cybersecurity, and with this in mind, we understand that this database can also be accessed not only by criminals, but also by those who fight cyber crime. And these include some private companies as well as law enforcement agencies and a wide range of bodies who somehow deal with solving the issues of cyber crime. Thus, we faced the following question: what should we do next? So if we shut down the WHOIS database, what is to be done next? So there is some legal fine line, since if we take a general look at the domain system, it will be divided into two main baskets, including the national domains that are subject to the national jurisdictions and functioning within the national legal framework. Those national domains do not have any obligations to ICANN because they do not deal with contractual relations. Thus, we don't have any leverage of impact on them, and we bring all the GDPR operations in conformity with our own vision, but there is one huge chunk of GTLD, generic top-level domains. So these are the general purpose domains, such as the oldest ones, including .com, .org, .ink, and so on and so .inc, and so on and so forth. There are many more new ones, .yandex, .moscow, .club, and so on and so forth. So these have concluded direct contractual obligations with ICANN, and a part of those obligations cover for collection and disclosure of registration data. So here we're dealing with some clearly cut obligations. So with the advent of GDPR, it became obvious that the registrating companies may face a situation when the registrators are accredited by ICANN and they function in this general purpose domain field. So they may find some conflict because they have to fulfill the contractual obligations to ICANN, but at the same time they do not exist in the vacuum. They act within the bounds of the legal framework of the country. So the jurisdiction of the corresponding country has the prevalent force, and thus there is a very strong stimulus. For example, $24 million in one of the cases. Thus, when it became obvious, and this problem was fully understood with all clarity, not as soon as it could have been, because on the 24th of May we didn't have any clearly cut solution, and this problem is aggravated by the fact that the destiny of WHOIS is not to be determined by ICANN as a single organization, because in our case all decisions regarding the management of the domain space are not made by the employees or the corporation, but the community surrounding it. This includes different stakeholders and experts. So there is a wide range of different gradings present within the system, and these working groups define policies that further on are adopted by the government of ICANN, by the management of ICANN, and further on are redirected towards the employees. So in this process we are assisting the decision-making process only. So we are not involved in some executive decision-making. We are not making some rapid decision and implementing them, because the WHOIS database does not belong to us. It is a distributed one, and it is collected from all around the world. So what I'm driving at is that the decision-making process is a very long one, provided that we take into account all the procedures and observe all the legislation. So by the 25th of May, we didn't have any solution. The only thing that had been done was a temporary specification issued that was additional to the main contracts. So the main provision of it was that on the one hand we insisted on the collection of registration data by the registering companies, but they should be entitled not to disclose personal data so that they could continue their business and without violation of the GDPR provisions. Before the time when we come up with a general model. However, the general solution is in progress, and the registering companies in different companies can elaborate their own solutions or their own rules of access to the full registration data for those agencies and organizations that they consider legitimate and that have a legitimate right to access the data. So they are provided with the opportunity to develop their own regulations and rules of access to the full database. Alexei asked me not to tell you everything about the current developments in terms of the WHOIS model management and in terms of its updating. I can do that a bit later. Thank you, Alexander. Here, I believe we have an interesting, amazing story of the international regulation being effective all around the European Union and trying to regulate the things that initially were self-governed or self-regulated. So we can go back to that a bit later in order to understand whether we should follow the European practices or whether we are facing some legal intervention. So how can we define that, and what other way we may select instead of blindly following this practice? Okay. I have a question which is related probably to the previous session, which raised the issues of personal data protection in Belarus, in particular the activities done by the specialized authorized agency. And the question is, why is that so important, and what body do we need in Belarus today? So what are the problems, what are the most relevant problems that are currently faced by the Republic of Belarus? So what is your vision here? Good afternoon one more time, distinguished colleagues. I'm glad to welcome all of you here one more time. Well, I was quite interested by the previous thought with regard to the legal intervention. So I'm confident that we are not dealing with legal intervention, but actually we are more dealing with some technological prevalence, which led to the understanding that Europe needs to regulate those issues. However, in our case, we don't have the understanding of the fact that this needs to be regulated on legal basis. So presently, if any one of us finds himself in some of the African countries, then he risks not coming back, because people in some of the countries eat each other. And cannibalism is one of the harshest examples, but we are probably one of the European states which is not a member of the Council of Europe. So we inevitably bump into the question or the conclusion that we should not somehow blindly follow the European legislation, because we're not a member of the European Council. So why do we need to follow their practices? At the same time, some of the bodies, including the state authorities in Belarus, they are exerting some influence on us in order to introduce the European legislation into our norms. So some of the Belarusian laws completely copycat the European norms.
A draft law, I think it's quite understandable. I'm not yet sure what's the name. It's not the strategy, not the concept, but it's written something like, it's like a bill. Well, it's not exactly a bill. I'm not exactly sure what was written there. Anyways, proceeding from that premise, it was actually approved by the experts of the Council of Europe, and it can be approved because it was approved by all of the relevant authorities in Belarus, so there is basically no relevant antagonism. But you know, it's either Africa where they eat people or the Council of Europe. Well, we have to catch up with the whole world technologically. Option 3 is the most favorable because the breakthrough made by Masquerade, by the tanks, by other Belarusian companies, that's already a demonstration of a trend. Of course, yes, those are individual cases, but I cannot remember any of the Russian cases. Yes, of course, there are giants like Kontakt and Yandex. You know, yes, of course, those are huge companies. We are not like that, and the products that were created will be part of a giant like Facebook. This is definitely not the Belarusian market. So there are some technical features that need to be regulated. The understanding that we're not part of the Council of Europe is one thing, but the fact that our legislation is going to be GDPR compliant, that's another thing. Those documents can be passed and functioning at any point. We are living in a different time, and I think that half of the audience, well, again, maybe not a half, but 30%, do not remember that wonderful time in Belarus when Yarib appeared. You know, right now we can be drinking a cup of coffee or taking a bath and making payments. We can be abroad and making payments because we're online and we have the access rights and we have the rights to carry out such payments within our country. There is no such system in Russia, but we do have it. Now, the question is, there is no particular law about it, but the system works. But the systems have to be brought in compliance with the legislation. Why? 10 years ago, we came to a bank when there was no Yarib, and we had to stand in a queue, and we had to fill in the special paper, and then the paper was processed, and then, yes, there could be problems with the handwriting and so on. But internet and technology simplify your life, but then we have the legal issue, because even the law enforcement point, we already talked about that. For example, today, if somebody stole a Bitcoin, basically we don't even know if it's a right, like a thing, property, right to own a thing, whatever. So all of that has to be regulated legally. So technically, the law on personal data will try to embrace all that is indicated separately in law. So Sergei from Moldova said that there is law on cybercrime, there is law on GDPR, there are like 4 different laws, even in their country. This is not one single law. Today we have some of the articles of a criminal code that imply liability for such crimes. So we have some of the general terms. We have legislation, but it's like 10 years outdated. So we need to bring our law in compliance with what currently does not exist in the legal practice, or rather in the laws. And so the body that is identified as the primary implementer of the provisions of this law will play a crucial role in checking whether or not this law works, because of course every law is good, but you need to check how it works, and right away we're going to have some feedback as to what is good and what is bad. So depending on how active or passive or energetic or initiative this body is, the law will succeed faster or slower. So, you know, even our colleagues from other countries that have adopted a strategy where the law just exists in itself say that this is a problem. It has to be more related to practice. Previously, when you were using, like when you were coming to a bank personally, your personal presence secured your personal data. But now you don't have to come to a bank to carry out a payment. Now the question is who and how protects your data. If this data is leaked, who is responsible? And the users won't even know that their data is leaked, because the bank will never say. Now the question is who and how will be able to use this data for embezzlement, for blackmailing. You know, if we talk about the bank, it's clear everybody will know if the money disappears, but we could think about medicine and the secret, the medical secret, and then again the census of a population, how these data are going to be protected. I hope that by the time of the census we will already have the law and it will be okay, but this is not necessarily so. I'll bring a practical example. So I was dealing with cybersecurity incidents for the last 15 years. So as far as I remember, I was raising the question of necessity of such law so that we use, say, administrative measures to solve the problems that arise. There was a student of one of the educational institutions who coded a special malicious software, keylogger, and he hacked the computers of over 400 people who studied and worked at that university. And he was basically controlling all of their correspondence, and he collected all of the personal data, internet banking, photos, and so on. He got all of the accounts, so he could use other systems, and from that university he hacked into several organizations, about 7 of them, including the governmental organizations, and he got a lot of data which he could use in a different way, in different ways. Of course, we identified him, we detained him. There was a sentence, and we had a quick chat with him. So, nobody really was interested in who was using their data and how. There was only half of people who said that they wanted the damage compensated because their data were used. So half of the people, I wouldn't say that they're absolutely indifferent about their data. Rather, they just don't have an attitude to them. So, again, what do people know about us? Yes, people know what we post on the social networks, photos, and probably some of the negative nature. Whatever comes to the internet stays in the internet. You think you're deleting it, but you may have deleted it. You may be thinking you have deleted it, but eventually it will pop up somewhere later. So, this document and this law needs to be passed as soon as possible and overseen by a competent body that will control how the law is implemented in the future. If this law acts passively, we shouldn't be expecting anything good. At the same time, this law should be proposing the changes to the administrative and legal, and criminal legislation. But I think it is much more effective to fine people because money works better than any of the disciplinary or criminal measures. The body has not yet been identified, so it's up to us. I think we will be looking forward to your suggestions as to what body this may be and what will this all end up in eventually. Thank you. Thank you so much, and I think it was said that it's not even clearly determined whether or not this body will be a governmental one. It is interesting to know, this was mentioned as one of the opinions, that this body on data protection, as opposed to a body that would be protecting the rights of the people in relation to processing personal data. So what they will be dealing with, it's technical protection, developing the norms, rules, standards, and security policies, or maybe it's going to be awareness raising, working with the business, and establishing the legal norms of working with personal data. Sergio, maybe you will explain what functions of such a body in Moldova are. I think I will start from the global practice that such body has to be fully autonomous because it seeks not only to enlighten or control, but also control and sanction the illegitimate processing of personal data. So this law has to apply the law to the operators who collect the data, spread the data, and so on. In which case, this body has the immediate objective to observe the law. So that one law is observed, what do we need to have? We need to have sanctions besides the body. So if the operators only processed the information they needed, or they took the copy of a passport and they used the data of the wife and the children and the family and so on. In this case, the body may either give the task to the operator to modify or erase the data. Among other things, it can impose fines. In the European Union, it could be up to 20 million or up to 4% of turnover. In Belarus, I'm not sure what is going to happen, but the sanctions need to be adequate. Now, who are the controllers? Controllers may be small, with a small database with 3 or 5 people. And there can be huge controllers that do the population census or process half of the population of Belarus, in which case the sanctions need to be adequate so that the body is able to apply. In Moldova, we first wanted to expose it to appropriate information so that it takes a look and develops its own ideas, but eventually it turned out that the body that was initially in place was not enough. It had to be autonomous. So we established the autonomous body that is not controlled by any other body, with the exception of the case when there is a criminal case. Then the prosecutor's office or law enforcement agency can come and check. But this body, it should not be subject to any control of any other body, and they need to have the right to control anybody, to check anybody, whether or not they're compliant with the law. There are some of the procedures that they can follow. They can issue opinions and recommendations. They can instruct and use some provisions that are mandatory for all of the controllers in public and the private sphere. And it also informs the subjects of the data so that they understand the rights and have their rights observed. So they help controllers to develop security policies and make decisions in specific cases. In the Republic of Moldova, it is mandatory to register all of the controllers. This means that every economic agent and every controller that processes personal data has to come to the center, apply, and get registered as the controller of the personal data. In this case, the center checks what information is collected, for what time frame, what use is designed for this data, and then they check the other details of control. It was introduced, among other things, in the European Union so that the controllers understand quickly what personal data are and what is going to happen if it is violated. In GDPR, they already finished that. Some countries of the European Union, for 40 or 50 years, they already have some points in protecting privacy. Say in Moldova, in the recent decade, only we've started to regulate the personal data processing. This body is very important. It's very important how the management is assigned. It's very important who you report to about your actions, what employees there will be, because there needs to be specific qualifications, not just lawyers. Saying that I'm a lawyer and that I know something about personal data is basically saying nothing. It's like, you know, so the specialization should be appropriate. It's like trying to go to a surgeon to do some dental work. So we need to know clearly what authorities this body will have, what it will be reporting to, and what requirements there will be to the employees. because they will be checking the National Bank or the Investigative Committee or any other very important institution. And if the person is incompetent and does not know what data are, they can just take the data and sell them. So the responsibility is extremely high. And the requirements that have to come from that body needs to be very strict. There has to be a separate, clear law where all of those authorities are stipulated. So you need to clearly control how the law is used. So this body needs to do the way it has to do, but not the way, act according to the law, but not according to its own interests. The National Center used to have 21 people, now it's 49, but we are already demanding the staffing of 100 because the amount of work is beyond any reasonable limits. Just so that you understand the way we organize the work. Control is itself, or the case in itself, is sometimes bigger than the case that the prosecutor or a policeman has to deal with. A case sometimes has many volumes that involve checking how legitimately everything was done and how the data was used. And we need to deal with all of the operators, and sometimes the decisions that are made are stricter than the punishment, the sanctions. Because if a decision is made on deleting all of the data, just imagine if this is a huge company, what will happen if they delete all of the data of the customers? They'll basically lose practically everything they've collected. So the competence is extremely high level, but the best thing is that we have a new body to protect the human rights and to see how the public institutions work with the data, including the economic sector and the private sector. Big operators have some practices and mechanisms on collecting that data. And they want this data to be legitimate. And they want the data to be processed only throughout a certain period of time. I would even ask a question, what do you think, how much time, for how long are the data valid? Is there any period of validity? Or there's a certain period for which I could sign a contract? Or are the data still valid in 10 years, and then 50 years, and then 100 years? Well, the majority of data that are in the passports do not change, almost never. They are issued for a lifetime. And these data are issued and published somewhere. So in 2 years, and 3 years, and 5 years, somebody still can sign a contract or pay a fine. And the body has to control and see the Facebook, the internet, the questionnaires, the contracts, and so on. Okay, thank you. I promised to pay some attention to questions from the audience. Let's start. I had just one request. If you have an opinion or something to say about what has been said or the protection of the personal data, please hold that till the end.
Good afternoon. I have a rapid question. It's quite specific, and it is not focused on some humanitarian criteria. So the first thing, speaking about the data protection officer, in terms of the implementation of the practices in businesses and other fields, so how do you consider this position today in the commercial sector? Speaking about the banks and other institutions, should this be a specialist of the CEO level, or is it just some research specialist who also fulfills the obligations of the duties of a data protection officer? And there is one more question. In your opinion, and as the international practices show, Well, we have some issues related to the visits of foreigners, massive visits of foreigners to the Republic of Belarus. Will there be some potential conflicts in this regard? Okay, so the first question is addressed to Sergei. Responding to the first question related to DPO, I have rich experience of appointing DPO, data protection officers, in the companies that I consult and that I train. And a data protection officer should be at the top management level. He should be subordinate to the CEO, otherwise this will be the violation of the regulations. So this is a must to appoint such a specialist, and in my practice there were cases when the members of the board of directors were appointed to this position. Anyway, you cannot appoint a person who processes personal data because he will face a conflict. According to his project, he should collect more data, but as a DPA, he should be protecting the persons whose data he processes. So this is a very similar position, because on the one hand, you receive salary from your company, but in many cases, you go against the interests of your company while protecting the personal data of its clients. So here there are no any potential conflicts. The DPO should be an independent person. He should be subordinate to the board of directors. And Europeans have already made several mistakes when they have stipulated insufficient independence and insufficient powers for a DPO officer. Currently, the GDPR is correcting that. So a DPO should directly report to the top management of a organization. And speaking about the composition of DPOs that are appointed by companies worldwide, including the companies in Eastern Europe, the leaders for this position are the persons with legal background and the compliance department members, as well as the IT security specialists. In many cases, prevalence is given to people with technical background, because if your company has already established a information security system, then it actually does work that is very similar to the work done by a DPO, because the DPO follows all the data flows and analyzes all the data storages. This specialist has already applied the confidential and strictly confidential grade system to the data processed by organization. So the only thing he needs is to introduce a new additional level of personal data protection into the system. Speaking about GDPR certification, there are no certificates issued today. However, most probably those will appear and will be based on ISO 2021. This is a standard related to information security management, because this is the most logical level and the most logical addition. This is about the standard that has already been introduced. If a company has implemented the standard, then it is ready to introduce the information privacy system as well. So my brief answer to your question is yes, indeed, a DPO should be an independent person, and this is the universally acknowledged European practice, because if you appoint him at the lowest levels of the company hierarchy, then it means that you haven't appointed anyone at all. I have one more question which is related to that. What about the Belarusian draft legislation, and what is the situation about a DPO in this law? Yes, indeed, the Belarusian law obligates a company to have a specialist responsible for personal data protection. The Belarusian legislation does not delve deep into the details here, and it does not stipulate all the competences in a detailed way. However, if you have seen this standard, I believe this is a huge piece of documentation, and here the legislators are drafting a concise version of the law, and I support the stance of Alexander Sushkov. I mean, the regulatory and the supervisory body should add some clarity and add some details to the functions. He should not only support the law, but also provide explanations regarding the way it is to be implemented, and also provide some consultations and have some produce some binding conclusions regarding the implementation of the legislation. And I believe this will be done by this independent body with regard to all the European and international standards. Just for you to understand, a DPO should be appointed by every operator of personal data, which means practically by every organization. So currently we are having this legislation being drafted, but we'll see how it goes in future. I would like to make some correction and some contribution here. In Moldova, when we signed the law in 2011, we copied a lot of provisions from the law on state secrets. So we took the law on the state secrets, took its provisions, and just introduced them into the personal data protection law, including the provision on DPOs or the officers responsible for personal data protection. So this provision was introduced in 2010 by the instruction of the government. This was extremely useful for us because once we adopted the new law to the GDPR, for the GDPR this is a novelty. Appointment of a DPO is a new thing, is a new trend, including all the duties and powers of a DPO. But for us, this was a positive development because back in those times we were prepared for that. So it would be nice if your legislation also define these obligations. Additionally, the most important thing for a DPO is his knowledge and his vision. In practice, it happens so that a director organizes a gathering, a meeting, and he appoints some person being guided by some opaque considerations. And this is not the correct practice because a person does not have the vision, a person does not have the skills and knowledge. But once he is appointed, he has to carry out some activities. However, the regulations of the GDPR suggested a new form, a new way to organize this. A DPO should be a person who has the experience and knowledge in the field of personal data protection. At the same time, the specialist can be outsourced, and we should acknowledge that today there are very few specialists who understand what GDPR is about. So with this in mind, Europeans took that into account and allowed companies to do some outsourcing and appoint someone from a specialized company, or they can also appoint some legal specialists who is specialized in personal data protection. All of that allows the operators to implement GDPR in practice, and DPO is about audits as well. So a DPO is either a company or an individual who also controls internal security within the company in terms of its compliance and observance of regulations. So a DPO should directly report to the governor or to the director, to the CEO, and submit all his notifications in written form. So the governor or the CEO should have a clear stance and should somehow abide by the recommendations provided by the DPO. Now, speaking about some major European events, in our case, these are the second European Games that are going to be held in Europe, and we are going to have an influx of tourists. There are a lot of infrastructural units that are going to be involved into these events. So what is going to happen here? What challenges will we face? We need to clearly understand when GDPR affects personal data protection and when it does not. GDPR actually does not affect citizens of the European Union, but it affects residents of it, those who reside in the territory of EU, which means that any person who is in Belarus, in the Republic of Belarus, is subject to the jurisdiction of GDPR if he lives in the EU. If a EU citizen comes to Belarus and goes to a bank, for example, or to some other institution, it does not mean that GDPR is applicable. At the same time, if some events, including the games, or some other events that were organized at the behest of the company which resides in the territory of the European Union, including the European games that were designed or invented in the EU, these will be also subject to GDPR regulations, because the person who designed those activities is a subject of GDPR. And in this case, if we have such complaints, then we will have to understand whether GDPR is applicable or not to the data processing. And there are a lot of opinions. Some persons claim that GDPR is applicable to all European citizens, but it does not mean that if you are a EU citizen and you go to the Republic of Congo and you ask the institutions there to implement GDPR, then this is not correct. But if a company from Congo represents certain services for the EU or for the citizens of the EU, then they will have to abide by GDPR. So speaking about the jurisdictions, you need to clearly understand who you are to address with all your complaints. And there is one more important thing here. If in the Republic of Belarus someone submits a complaint, there are no bodies, there are no laws, and no mechanisms for personal data protection. So presently our data, our personal data, are not somehow protected on a legal basis to the full extent. Okay, thank you. There was a question here. My name is Anton, I'm a research specialist, and I have a question to Alexandra Kulikova. The WHOIS database was indubitably very useful for us, so I'd like to find out about the prospects of the communications between the owner of the resource, who, for example, and the parties that may want to buy some domain. Yes, indeed. I hoped that you would ask this question, and I wanted to tell you about the ways that we're going to employ while tackling this problem. On the 25th of May, when GDPR came into effect, we were not ready, and we didn't have a unified vision of the way we're going to treat WHOIS. We only issued a temporary specification that allows to complement the existing contracts and exclude situations when our partners may find themselves in a case of GDPR violation. So we needed to enable them to collect data but not disclose them. So this addition was introduced on the 12th of May, and it was prolonged in August for 1 year in order to provide some time for the community that I told you about to develop a unified system of access to registration data preserved in the WHOIS database. It means that not every regulator is free to come up with his own rules, but instead we should have a unified platform and a unified vision regarding the parties that should have access to the database. Well, if you take a look at WHOIS today, then you will see that a lot of data that previously existed are no longer disclosed. And certainly there may be some problems. Not everyone might have fulfilled the homework, so to say, but we should find out what organizations particularly should have access to the database. And there are a lot of opinions here. One of the categories that are most legitimate in terms of access to the database are the law enforcement agents. So the question is who the law enforcement agencies are, because in different states, in different countries, these can be completely different structures in terms of the nature and in terms of the activities, as well as line of mandate. Sometimes investigations are performed on an outsourcing basis. So this is a pretty complicated scheme which may be quite unique in every given state. So there is a separate job for us, a separate objective to figure out who law enforcement agencies are and what their mandate is. some countries may grow paranoid about that, may fear being forgotten, being left behind due to some geopolitical tensions. But I hope that we will not face such a situation. So far, we haven't come up with a final solution, with a final decision. But this is one of the problems that is being discussed today. There is one more issue, which is a technical one. I mean, how can we ensure the functioning of a multi-level system? There are many solutions today, and we're probably going to use the presently existing protocol, but the next generation after Hughes, which is called RDAP. And this one allows to split the database into different segments, into full and limited segments. Further on, we also should think about the accreditation system and the way organizations are to be accredited. How are they going to be authorized, and will they receive some passwords? And if yes, in which way is that going to be done? Whether this should be done on a paid or free basis, whether there should be some annual fee introduced, or some fee for every given request submitted. These discussions are in process today, and I have told you that the community is developing some policies for domain space management. So this process has been launched, I mean the policy development process, and this one was launched in August, if I'm not mistaken. So by spring or summer of the next year, they should finalize and come up with a final decision, final solution for all the players in this field. So this is an open process. You can attend it, you can participate, and you are free to come up with your own solutions and recommendations. So I'd like to point out that in this discussion, the most proactive participants are the law enforcement agencies, as well as some legal agencies dealing with intellectual property rights, because they have to somehow get in touch with the registered bodies with regard to some violations. There are also some agencies that participate in investigative activities, or some academic organizations as well. So here we mean all the stakeholders that have woken up because due to some reason they require access to a fully fledged database. So the objective that we have set for the upcoming months is to come up with a final solution and elaborate a unified model that would to the maximal degree satisfy different groups of stakeholders on the global scale. And this is really hard to achieve because the legitimate participants or users of the database are quite miscellaneous, are quite varied. So it is really useful for Belarus to follow this process. And on the 9th of October, we're going to hold a webinar dedicated to this very topic, which will update you on the recent developments and the discussions. It will be interpreted into all the UN languages. There'll be a video streaming, which would allow you to receive all the information live. So I'd like to underscore that this process is an open one, and it is critical that we take into account the voices from different communities so that no one is left behind, because this new model should take into account the interests of the maximal amount of players, because this brings us to the issue of human rights protection and the opportunity for the state authorities and other stakeholders, which is a different story actually, to perform high-quality assessment and investigation of cyber crimes. So this is a practical implication that we should think about here. So if you have any questions, you are most welcome to.
Okay, so if you have any more questions, let's create 2 or 3 questions in a pack and give a brief answer. Good day. I think it's more of a question to Alexander. You said that an organization must be fined. But what to do if the offender is a public agency? Basically has no money of its own. Well, I said it should be fined because over the 15 years of experience, I have seen the ineffectiveness of different moralist functions. Criminal liability is sometimes not functional because we punish the people, but they do not commit crimes all by themselves. They do so because they're instructed so, because their job instruction is like that, or for whatever other reason. So there is a whole context. So we punish one individual, but the one to blame is the whole organization that designed the order so that they could shift the blame. If we talk about governmental organizations, there is one more problem. We talked about the high-tech park, wargaming, IPAM. There are problems, and they openly speak about that. It's very seldom that residents of high-tech park want to work on projects in Belarus. Why? First, it's because you earn 3 times less here than if you do something for export. Second thing is that if you're doing something in Belarus, then the controlling bodies, a whole plethora of them, will come and ask, now, why is this product evaluated at 1 million but not 753,000? You know, estimating the cost of product and cost of labor and so on is something not developed here, and public agencies do not know how these products are created. Now, they want to have a system, they want it to work, but they cannot even write terms of reference. So, of course, we cannot fine public agencies because this will damage the budget and the people who form the budget with their taxes. But that's exactly why you need to have a good, competent initiative body that would help the public agencies to establish the proper security that will last for years, instead of spending a lot of money on nothing. So we need to work with the resident companies so that we do our products together. You see, public agencies are specific people. Today, there are certain people, tomorrow they're different already. So, for example, without the RIP, the system of distant payment, the costs would be completely different, and that's the same thing is with the public agencies. It's just my opinion that it is okay to fine for these things, because if people are anxious, then they will take care to appoint proper people, because you know, sometimes you may even have good software, but you may not have the people to set it up. In the public sector, these problems are quite obvious, and they may be even more intensive than in the commercial sector, because in the commercial sector, they are earning money and they pay some money, spend some money on automating processes. But public agencies don't work this way so far. So, Sergio, are there any more questions? There's just one small point that I would like to add. To talk about the information systems. We heard about RIP and so on. They have the information protection systems that have been attested. So our regulator comes and checks. So we cannot say that they're not responsible for anything and not protected. Yes, of course. Yes, of course. They are responsible. They're in charge. Oh, yeah. What I wanted to say is that in Belarus, we currently have legislation. We have a law on informatization and protection of information. So it stipulates that limited access information has to be protected, irrespective of whether it is public or private. How the new law will force entities to protect information? Well, there will be different levels. There won't be really classified information. There will be just 4 levels of access that will reflect the order of operational and analytic center up to a certain point. So there will be the level of critical importance of these data. In fact, I think half of the data can be made fully open. So, but you need to stipulate that in a law so that you don't have to create cumbersome systems. You need to create them in cases when the critically important objects exist. One more question from a young man, and we will get back to your response. Hello, my name is Alexei. I'm an individual entrepreneur, and I have a question, I think, to everybody, but primarily to Alexandra. What do you think? The registration of domain names in Operation and Analytical Center, I think you've heard about that. This is a useful tool. Or is it? Is it necessary? Do you think? I don't understand the registration. Okay, if we register a domain name in Belarus, all the entities also have to be registered in the Operation and Analysis Center in Belgium. It used to be OAC previously. Is this a useful tool, or are these functions superfluous? We talk about national domains. .by, .bel. No, it's not a question, it is a statement. Now, as I have already mentioned, when I was starting out, the country or national domains are fully within the jurisdiction of a respective country, respectively the rules according to which domain or domains function. Well, we have two. In Russia, they have three. One of them is like a quasi, like a ghost domain, .su. So they are regulated by the legislation of respective countries. So nobody can tell you whether or not you're managing .by or .bel appropriately or not. You have this kind of structure, correct me if I'm wrong, where de facto the domain management, the administrating of domain is shared among the two organizations. On the one hand, this is OAC, that is basically the administrator of the national domain. In fact, the technical function of supporting the register is performed by Goster-by Reliable Systems. That's exactly the company, Hoster.by, that's exactly the company that's hosting us today. This is the practice that formed years ago, and it's still functioning, and it is not exactly appropriate to ask the question whether or not it is good, because IGF is one of the places where you can ask this question to people, not in ICANN, because ICANN does not have, as I have already said, we don't have contractual obligations. We have no ways of influencing. Okay, my question is whether or not it can be useful for ICANN. Well, it is important that national domain are controlled stably, so that the whole hierarchy of domain systems is not a threat to anything, so that there are no factors that would undermine how stably the Internet functions within the national segment. As far as I know, for the whole time of existence of .by and .bel, there were no such incidents. So I think the system that there is optimal for solving that task. It doesn't mean that everything is set in stone and cannot be different. There are examples in the world where the systems of governance are reformed, like that happened so in Russia. This is a living process. So you shouldn't be asking ICANN that question. I think you should rather ask that question to the Belarusian community that takes part in making decisions. I hope this answers the question. Yes, it does. So I hope this is probably the final question. This is the final session, so the next question can be asked at the next IGF next year. Sergio, a question to you as a representative of public agency. How did you deal with that? Well, the public agency cannot be fined, of course, because this is budget, but you can impose sanctions on the head or the person who committed the violation. Okay, thank you. think that today we kind of had a continuation of the dialogue that we started a bit more than a year ago, and we will continue it because this topic is an ideal one for the questions of internet governance. It has to do with the state, with businesses, with international organizations. This is one of the stepping stones of the existence, one of the pillars of the existence of information society. And I hope our next discussion is going to take place with participation of the Belarusian authorized authority on protection of personal data. And so I think that for the next IGF, we will already have expert events and other events dedicated to that topic. Thanks for being with us now. Of course, this is kind of manipulation because all of the people here are people who are interested in that topic. But now, looking at the slide, we cannot say that there is nobody in Belarus who would be interested in protection of privacy and personal data. If there are people who are not indifferent, then we can discuss the future of this thing. Thank you.